Thanks for watching this video brought to you by AN Immigration Services and Consulting. Please ensure that you watch this video at high resolution for best video quality, as we are going to show you a flow chart in this video. The content in this video is for reference only. Please seek professional advice about the content in this video. Please like and share this video and subscribe to our channel. Although this video is just over 10 minutes long, more than 10 hours of work have been put into the preparation of this flow chart. You can see the complex legislative requirements easily in detail and in full in applying for this visa and the eligibility criteria that you have to satisfy. Let us be part of your journey in Australia and support you throughout this journey. In this video, we will walk through the application process and the visa eligibility criteria by following a flow chart for applying for a Subclass 494 Skilled Employer-Sponsored Regional Visa in the Employer-Sponsored stream. The red lines in this flow chart are answers no to the question in a decision step. Please simply commence from the start at the very top, answer the questions in each decision step and follow the direction of the arrows. 494 is a provisional visa. That is, it provides a pathway for permanent residency for the visa holders. 494 visas enable regional employers to address identified labor shortages within the region by sponsoring skilled workers where employers cannot source an appropriately skilled Australian worker. Let's start. There are 2 steps in applying for this visa. The first step is to submit a valid visa application. If your application is not valid, your application will not be successful even if you meet all visa eligibility criteria. For any visa applications, always check whether there are any visa conditions, act-based or regulation-based restrictions that will stop you from applying for the visa. There may not be such restriction, or the restrictions may not apply to you. However, it is the awareness of any restrictions or waiver that is important. There are 3 stages for a business to sponsor you for a skilled employer-sponsored regional visa. The first stage is the sponsorship, which is not covered in detail in this video. In this stage, an employer applies for approval as a standard business sponsor. The second stage is the nomination, which is also not covered in detail in this video. In this stage, the employer, that is, the sponsor, nominates an occupation for you as a prospective skilled employer-sponsored regional visa applicant or existing skilled employer-sponsored regional visa holder. The last stage is the visa application, which is the focus of this video. You are the person identified in the nomination. You apply for a skilled employer-sponsored regional visa in the employer-sponsored stream that was identified in the nomination. There are very limited circumstances in which you can submit a non-internet application. If you are authorized to submit a non-internet application, please ensure that you follow strictly the instructions from the departmental email. Most of the applicants will need to submit an internet application using Form 494V. The visa application charge at the time of application is $4,640 Australian dollars as of the 12th of April 2024. In respect of your 494 visa application, a person must have nominated a proposed occupation in the employer-sponsored stream for you. Let's say we call this person the nominator. Your visa application is in the employer-sponsored stream, which is specified in the nomination. The application must identify the nomination through a departmental identifier for the nomination that identifies you as the nominee. You are required to provide the departmental identifier in your application. The nomination has been approved and the approval has not ceased. If not, a decision in respect of the nomination has not been made yet. The nominator is not barred from being a sponsor. You need to make a declaration whether or not you or any accompanying family members have engaged in any prohibited sponsorship-related conduct. If you pay a sum of money to induce an employer to offer you a nominated occupation, this is an example of prohibited sponsorship-related conduct. Unless you are exempted, you need to declare in the application that your skills have been assessed as suitable for the nominated occupation by a relevant assessing authority and the skills assessment is not for a 485 visa. You are only exempted from the skills assessment requirement if you are an academic applicant or Subclass 444 or Subclass 461 worker. We have included a link to the relevant legislative requirement defining these applicants. If you seek to rely on the exemption, you need to make sure that you fit the definition of an academic applicant or Subclass 444 or Subclass 461 worker. You can apply for this visa in or outside Australia. If you apply in Australia, you need to hold a substantive visa, a bridging A, B or C visa. A substantive visa means a visa other than a bridging visa, a criminal justice visa or an enforcement visa. If you have submitted a valid application, the department will process your visa application, assessing whether you meet all visa eligibility criteria at the time of decision. The second step is to check whether you satisfy all visa eligibility criteria. There are various public interest criteria and special return criteria that you must satisfy, including the character and health requirements. Any accompanying family members included in your visa application also need to meet public interest criteria and special return criteria. Public interest criteria also apply to any non-accompanying family members. These criteria for the family members to satisfy are called one fails, all fail criteria. This means that if any accompanying or non-accompanying family members do not meet these public interest criteria and special return criteria, your application will be refused. At the time of decision of your application, the nomination has been approved and the approval of the nomination has not ceased. The nominator was an approved work sponsor when the nomination was approved. This deals with rare situations where the nomination is inadvertently approved after the nominator's approval as a sponsor has ceased. The position associated with the nominated occupation is genuine. This criterion is usually considered satisfied if the related nomination is approved. However, the department may carry out further assessments if adverse information about the sponsor has come to their attention, or there is information suggesting that the position has been created primarily to assist you to obtain a visa rather than to address a genuine business need. You have genuine intention to perform the nominated occupation. Further considerations are warranted by the department if your qualifications or competences or employment background are significantly inconsistent with the nominated occupation. There is no adverse information about the nominator or its associates unless the department deems it reasonable to disregard such adverse information. Adverse information is any adverse information relevant in determining a person's suitability as an approved sponsor or a nominator. For example, the department may receive a tip-off about your nominator having contravened a law of the Commonwealth, a state or a territory. The discretion to disregard the adverse information depend on many factors, for example, the nature and seriousness of the adverse information. You have not engaged in any prohibited sponsorship conduct in the last 3 years before your visa application unless the department deems it reasonable to disregard such conduct. Unless your occupation is an exempt occupation, you are only permitted to be employed to work in the nominated occupation. You can only be employed to work in a position in the nominator's business or in the business of an associated entity of the nominator. We have included a link at the end of this video to a legislative instrument showing all occupations exempt from this work requirement. If you do not hold a passport issued by the United Kingdom, the Republic of Ireland, the United States of America, Canada or New Zealand. You need to have undertaken a specified English language test and achieved the required scores. One of the more well-known specified English language tests is IELTS. Information about other specified English tests and the required scores are provided in a link at the end of this video. Also, the test must have been conducted in the 3 years immediately before the date of application. Unless you are exempted, you must be under 45 years of age at the time of application. This age exemption is only given to those who are academic applicants, Subclass 444 or 461 workers, science applicants, Subclass 457 or 482 workers and regional medical practitioner applicants. Please refer to a legislative instrument provided at the end of this video for the definition of these exempted applicants. Academic applicants and Subclass 444 or 461 workers also enjoy exemption from skills assessment and working experience requirements. For other applicants, they need to possess at least 3 years of post-qualification experience in the nominated occupation on a full-time basis. For those applicants who are not exempted from the skills assessment requirement, they can use recent skills assessment or previous skills assessment for their previous 457 or 482 visa application. If you rely on a recent skills assessment, at the time of application, your skills had been assessed as suitable by a relevant assessing authority for your nominated skilled occupation. 485 temporary graduate visa skills assessments are not acceptable in relation to this visa. It is important to note that assessing authorities may set different standards for skills assessments for the same occupation. Temporary and permanent visa programs may have differing purposes, and the different standards of skills assessments reflect those purposes. For example, 485 visas are aimed at assisting a graduate to gain skilled work experience in Australia. 494 visas are aimed at an applicant who already has relevant skilled work experience in the relevant occupation. The standards for a skilled assessment for a provisional and permanent visa such as the 494 visa will therefore generally be at a higher level. If there is validity period for your skills assessment and the period does not end more than 3 years after the date of assessment, the period has not ended. If above requirements are not met, not more than 3 years had passed since the date of assessment. Irrespective of whether you use a recent skills assessment or a skills assessment from your previous 457 or 482 visa application. If your skills assessment was based on a qualification you obtained in Australia while holding a student visa, your qualification must come from studying a registered course. We have included a link to the Commonwealth Register of Institutions and Courses for overseas students where you can check whether your courses are registered. If you intend to rely on a previous skills assessment from your previous 457 or 482 visa application, the occupation to which that visa was related was the nominated occupation. In your previous 457 or 482 visa application, you were also required to demonstrate having the required skills for that visa, and the demonstration included your skills having been assessed by relevant assessing authority as suitable for the occupation. In addition, your previous skills assessment was not for a 485 visa. Thanks for walking through the application process and the visa eligibility criteria with us. Please like and share this video and subscribe to our channel, so that we can provide more content to support you.